Good morning friends. Welcome to the YouTube channel Advocate Amit Kumar Gupta. In my series on the income tax cases, the case which I am going to discuss today is Tata CUMMINS Private Limited versus Union of India and others. This case has been decided by JHARKHAND High Court. Matter has been reported in 447 ITR at page number 455. This is a matter of writ court and the date of the judgment is 8th March 2022. Friends, as we see that whenever the assessee approaches the department for taking its refund, then the department becomes very particular in granting those refunds. Especially in the cases when the appeal effects are given. Nowadays we have seen that when the assessee files its return of income, the returns are processed very fast and the refunds are also coming to the assessee in a very quick way. But in the cases where the appeal effects are given, in that case still the refunds are not coming by its own. The assessee has to pursue the department. The other case is that when the refunds are due to the assessee and the department finds that some outstanding demand is there in the subsequent years, then department has been given power under section 245 to adjust those outstanding demands against the refunds of the assessee. If the balance is due, then it should be paid to the assessee. But for adjusting the outstanding tax with the refund of the assessee, the mannerism is that the assessee should be given a prior intimation before that adjustment, and that intimation should be prior to adjusting the refund. That intimation cannot be spot intimation or the subsequent intimation, meaning thereby that it is not like that you give the intimation and you just adjust the refund, or after adjusting the refund you gave the intimation to the assessee. So in this particular case, the refunds of the assessee were pending. The department adjusted the tax demand of assessment year 2014-15 with those refunds, but no intimation has been given to the assessee. So the assessee filed a writ petition before the JHARKHAND High Court that the department has not followed the proper procedure. The refunds have been adjusted under section 245 without following the procedure of section 245, that is without intimating the assessee. In this respect, there is a very famous case of the Supreme Court which says that if any procedure is there for a particular work to be done, then that procedure should be followed. And that work should be done only according to that procedure and not in any other manner. So it means that whatever the procedures are there in the statute, those procedures should be strictly adhered, and if those procedures are not followed, even the high courts allow the writ of the assessee. So this happened in this particular case because the assessee was not given the intimation and the refunds were adjusted with the demand without giving the intimation to the assessee. So the court said that whatever the adjustments have been done is not as per the law, it is not into the four corners of the law, it is not as per the statute. So whatever the adjustment has been done under section 245, that is bad in law and it should not be given effect to. Friends, this case is very important. We see that CPC is doing very good business for the income tax department by crossing all its limits. If they give the intimation also and you give any reply to the CPC, even then they are not considering those replies. So it has become only a mere ritual, and it is very saddening situation for the assessee that the assessee has to go for the various appeals for that things also. So it has also given a fast track to the litigation, and due to this litigation is also increasing. But in this particular case, the department has to go to the writ court and get the order of cancelling the whatever the adjustment has been done illegally by the department. Friends, at the end of this video, I am once again repeating the name of the case. The name of the case is Tata CUMMINS Private Limited versus Union of India and others. Thank you, friends.